lawyers, like any other businessman or any individual, don't like to hear that a client is disappointed in what they've been able to do for them. An interesting coincidence that occurred to me just this week was I got a note from a lawyer friend of mine in Northern Virginia, in Fairfax, Benjamin Glass, who recounted that he had a client who was severely injured in an automobile accident, and the client was unhappy with the result that he obtained for him. And the reason the client was unhappy, according to Ben, was that he didn't get as much money as he thought he deserved, and as Ben said, probably should have received as a result of the injuries he sustained and the damages that he had. But the problem was that the insurance company that represented the other party, the party at fault, did not have but $50,000 in coverage, in liability coverage. Now, that's not the fault of Ben's client, and it's not Ben's fault. However, the insurance company that sold Ben's client his insurance policy should have gone over with him thoroughly a situation such as this. Ben's client only had minimum limits of liability himself, which meant that he only had $25,000 of underinsured motorist coverage on his contract of insurance. Now, I've always told my clients that I think that they should review their auto insurance policies every term. In other words, if your policy is for a year, on like the 11th month, when you get that renewal notice from your company, you need to sit down and see what amount of coverage do I have and what amount do I need if something catastrophic happens. Because you never know when you're going to be injured and maybe not be able to work or to have your medical bills paid in full. And so what I recommend my clients do is get on the phone with their insurance company's representative before that term expires and say, do I have enough coverage? If I get in an accident that's not my fault and I can't work for 6 months, I don't want to go into my savings to pay my expenses. How am I going to protect myself? Especially if the other party doesn't have enough insurance to pay any judgment that I may be able to get against him. And you should look at the terms of the underinsured, uninsured motorist provisions of your own policy and raise those. We recommend at least $300,000. For most people, that's going to be sufficient to carry them through a period of time when they may not be able to work. And how underinsured and uninsured motorist coverage works is your company will pay you what deficiency there may be if you get a judgment against someone who doesn't have enough money to pay it himself. In other words, if the other party's insurance is not enough to pay a judgment that you could get, your company will step in and make up the difference. And the insurance coverage for UM and UIM is very little. You're not going to be paying an arm and a leg on your policy to get sufficient amounts of coverage, and it certainly will pay you back in the long run. I had a client a few years ago who was injured seriously. He had 3 operations for a double compound fracture to his right leg. He was unable to work for 6 months. We went to court. We got a $250,000 judgment against the other party. However, the other party only had $25,000 in coverage. So, and as usual in these cases, when they have low insurance liability coverage, they don't have much in the way of assets that you can go after to satisfy a judgment. But what my client did have was $500,000 in uninsured, underinsured motorist coverage, and his insurance company paid the $225,000 of the judgment that the other party's insurance could not pay. And while we're at it, I want to mention something else that you should consider. One of the things that insurance companies have to offer people in Virginia who buy auto insurance is MedPay. Now, MedPay is an additional election you can make on your insurance coverage, on your auto coverage. It's very cheap. The benefit of having MedPay is that it will pay you the cost of your medical treatment, regardless of whether your own insurance company, health insurance company, has already paid it. And the benefit from that is this. If you're injured in an automobile accident and your health insurance comes in and pays, or if it's Medicare, if they pay, if a third party's at fault, your insurance carrier or Medicaid is going to come back after you sue and get a recovery against the responsible party, and they're going to say, we want our money that we paid you back because it was the result of a third party's negligence. And you're going to have to give it back to them, or at least a substantial portion of it. So MedPay doesn't work that way. MedPay is not subject to subrogation by your insurance company because you've entered into this contract to pay for them to pay you if you are injured and have medical bills. The other benefit of MedPay is that you can stack coverages. If you have two cars insured under a policy and you're injured while operating or riding in one of them, and your medical bills are, say, $25,000, and you have $10,000 in MedPay, you can stack those two policies on the MedPay together to get $20,000 in MedPay. Now, that's not going to cover all of your medical bills, but it's going to cover, 80%. And that's a good thing to have because that's money that goes into your pocket, regardless of whether Anthem or Blue Cross or whichever insurance, healthcare coverage you have, has already paid the cost. So look at your insurance policies, talk to a company representative, and see what you can do to protect yourself against a catastrophic accident.